My time has expired, and I want to turn it over to Mr. Takano for his questions.
My first question is for Mr. Gaffney. Mr. Gaffney, how do you foresee the so-called Gardner or pro-veteran canon, which directs courts to interpret veterans' benefit statutes liberally for their beneficiaries to be treated by the courts post-Loper?
Thank you for that question. So Gardner is a canon that, as you said, directs courts to look at veteran statutes in a pro-veteran manner. And it's what's called, as my colleague mentioned, a substantive canon, meaning that it's not looking at the specific text of a statute, but at who the statute affects. Another example of a substantive canon might be the rule of lenity, where courts interpret criminal statutes in a way that favors defendants in criminal cases. So if there's an ambiguity, then they're not going to be imposing harsher penalties than what Congress may have intended. Now, some judges, including a couple of Supreme Court justices in the recent case Rudisill v. McDonough, expressed skepticism as to whether these substantive canons may still have a role, but they are still good law, and so this may be something that a court uses when trying to decide the best meaning of a statute in Loper.
Do you see them at all, do you see the pro-veteran canon potentially in jeopardy?
It's hard to say.
Hard to say.
As I said, several justices have expressed skepticism, but there hasn't been an official rule.
In Loper, the Supreme Court stated that while it was eliminating Chevron deference, this does not, in turn, foreclose agency discretion or courts' use of agency expertise. The court went on to say that when Congress delegates discretionary authority to an agency, it is now the court's role to define the limits of that discretionary authority. If Congress explicitly leaves discretion to an agency, is it not an overreach of power for the courts to insert themselves when Congress made its intent to delegate the determination of particulars to an agency?
That might depend on exactly what a court is addressing. If the delegation is clear, then the court should defer to that delegation as the clear intent of Congress. If there is some question about exactly what the contours of that deference are, that might be a place where a court could step in and try to decide where those fuzzy contours might be.
But could we objectively say that there is definitely a shift of power to the court to decide these things?
I'm not sure if it's a shift. Courts have always had some power to interpret statutes, and whether that's with deference to Chevron or not, depending on the context. But Congress could use its power to make legislation that is as clear as possible in order to shape how the courts come out on those things.
Well, how is it decided where Congress's grant of a discretion ends and the court's authority begins?
That's unfortunately a question that courts are going to take up and that Congress can respond to.
It's in the court, yeah.
Right.
So, Mr. Gaffney, does Congress have the same ability to hold courts accountable as it does agencies?
To some degree. The lower courts are creatures of statute. Congress can amend their jurisdiction. Congress can choose how much to appropriate to the courts. So Congress does have some degree of control over the courts and their operations and the standards of review under which they look at agency actions.
So, to all the witnesses, do you, and very briefly because I only have so much time, do you think legislative drafting and negotiations will be more or less difficult following Loper, starting with Mr. Squitieri? More or less?
I suppose I'm not sure. Congress will have to put the policy on the
You're not sure, Mr. Gaffney?
Congress would most likely have to consider the impact of its legislation and the lack of deference more than it would have.
Dr. Wallach?
Yeah, I suppose they're more consequential, and maybe that makes them more difficult. I think that's all right. This responsibility is supposed to be on Congress.
Mr. Vecchione?
At oral argument for Loper, Paul Clement said that Congress will now have to, they can't just hope that the presidential campaign will go the way they want and their friend will be there to make the laws. They're going to have to make the laws. So I think it's going to require more work.
Got it. Well, how will Loper affect bipartisanship and how lawmakers advance their political interests? I won't have time for each of them. I'm going to have to leave that to one of my colleagues to ask that. Again, for all our witnesses, would Congress benefit from an increase in legislative branch appropriations to support bringing on more staff in response to Loper? Mr. Squitieri?
More appropriations for congressional staff?
Yes.
Yes, I believe Congress would benefit from that.
Mr. Gaffney?
Assuming that Congress wants to take on more of this rulemaking and taking on some of the agency functions, that would probably be beneficial.
Dr. Wallach?
I think it matters how you expand appropriations. I think committee staff is the best place to invest in expertise in Congress.
So, I mean, if we're not deferring to executive expertise, and the executive, the delegation having mostly the final say, Congress, in order to take that power back, is going to have to build up its cadre of expertise. Is that what you're saying, Dr. Wallach?
I'm in full agreement, yes.
Mr. Vecchione?
NCLA doesn't have a view on this, but I do. And I think that the executive, relying too much on the executive experts has caused Congress some problems.
So in response, if we don't want it to actually be decided by unelected judges, we're going to have to build that expertise here in Congress. My time has run out, and I yield back.